And we're live. Welcome back, everybody. This is a new kind of version of what we've been talking about for a really long time. Today is a live video that has to do with the FTC's recent move to ban non competition agreements. Now, I had thought about this for a couple of days. Do I want to make a pre recorded video and just push it out there, or do I want to do something live and give the opportunity for some of my followers to ask questions as we go through this process? And I went, let's do a live show. This should take probably 15, maybe 30 minutes. The goal here is to help you understand what is going on at the Federal Trade Commission and what is going to happen with this proposed rule that we've all been hearing so much about. So earlier this week, on actually January 5th, a couple days ago, the Federal Trade Commission pushed out a proposed rule. Now, to understand a proposed rule, we have to kind of back up and say, well, what is the administrative law state? What is this thing we talk about when we talk about administrative law? Typically, when you have a law, the Congress, Senate, and the House pass a bill, goes to the executive signs the bill, and that becomes a law. And then the law gets enforced by the executive, and the ability to appeal the enforcement goes to the judiciary. Well, that's not how administrative law typically works. It does to an extent, and we're going to talk about that right now. Here's what happens. The Federal Trade Commission is empowered by a statute that was passed by Congress, but the FTC is given the authority, the latitude to make their own rules. And when they make a rule, they have to propose the rule. And the rule goes into this thing called the Federal Register. And in the Federal Register, you have the opportunity to make comments. We're almost at the comment phase for this proposed rule, but we'll get to that in a moment. Once this proposed rule is finalized, it becomes the law of the land and it gets enforced against all sorts of businesses and entities all across the country. You can appeal it. You can go through the process within the FTC itself, or you can just go to the judiciary, go to the district courts and sue. And we'll probably see that. But I'm getting ahead of myself. Let's break down this proposed rule. I want you to think of this video like an unboxing video, right? I want you to say, hey, what are we talking about here? What is all the hubbub about? So let's get the facts straight. What is a non-competition agreement? That's a really good question. Let's start off with that. A non competition agreement is a post employment restrictive covenant. What that covenant does is it says, hey, after you leave, there's certain things you're not going to get to do. Now, there's a lot of different post employment restrictive covenants out there. There's things like non solicits, non-disclosures, non-disparagements, training repayment programs, liquidated damages. And there's these things called non-competition agreements. A non-competition agreement has a couple pieces to it. One, it has a duration. How long will it go? It has a geographic component. How wide will I enforce this? And then finally, it has a what is the thing you can't do anymore? What is the business that you can't do? Those are the three factors that determine a non competition agreement. And these things are everywhere. And that's why this stuff is so fascinating. Look, folks, approximately 18% of American workers are covered by a non competition agreement. 30 million Americans are covered by a non competition agreement right now. Right now. And about 38% of workers have been covered at some point by a non competition agreement in their lives. So, what's happened? Look, before the FTC got involved, there was actually bicameral legislation. There is the thing called the Workforce Mobility Act. This is a act or a bill that's been in the House and in the Senate. It has bipartisan support, but it's been locked in a committee. Again, these are trying to ban non competition agreements. So the FTC said, you know what? Let's just do this ourselves. And what does the commission expect to happen? Well, the commission estimates that the new rule could boost wages by nearly 300 billion. That's billion with a B, and expand career opportunities for about 30 million Americans. So many people stay at a job because if they were to leave, they'd get sued. And the FTC is stepping in and saying, let's not have that be the thing that happens. So let's get to the proposed rule. So we start off with the proposed rule, and I'll link the rule in the show notes. But we're going to do an unboxing. This is the rule that came out January 5th, just a couple of days ago. It begins off with the overview of what they're trying to do. You see that 30 million Americans. You see the idea about the amount of wages that are being looking to be increased. Understand this. If you're able to quit your job and go work for a competitor, your competitor might pay you more. Even if you're not going to solicit any business, you have the expertise that your competitors want. And your employer does not want you to do that. And so what they do is they give you a non-competition agreement. And again, 1 in 5 American workers are bound by non-competes. This is not just executives or people selling businesses or anything like that. It is salespeople, entry-level people in all sorts of industries bound by the non-compete. So here's the proposed rule. After you get the background, you get to read about it. There's also some hyperlinks above. You can check out more of the fundamentals behind the rule and why they think it's so important to do right now. A little bit of a little more political, interesting stuff here. It appears that the FTC will have the votes to pass the rule. So even if they do the modifications, which we'll talk about in a little bit, on party lines 3-2, this rule can likely pass, and then it will be enforced against every company in the country, unless it gets enjoined by some sort of litigation, which again we'll get to as we go through this rule. So let's get into the proposed rule. Start off with definitions. Dude, I love a good set of definitions. It tells you what a business entity is. It tells you what a non-competition clause is. And they have a little functional test that they talk about. And so what happens so often in our industry, in our country, is that they don't call it a non-competition agreement. They call it a non-disclosure. And there's some language that makes it look like maybe you're going to be competing with somebody, maybe you're not. In these cases, they're going to have this test that says, okay, what is really at stake here? What am I really talking about? Does it prevent me from doing what I'm trained to do? So if a non-disclosure, for example, is written between an employer and a worker, and it's effectively precludes the worker from working in the same field after the conclusion of the employment's relationship, it's going to be considered a non-competition agreement. So just because the contract doesn't say this is a non-competition agreement does not mean it's not a non-competition agreement. So it's going to be really interesting to see who all is covered by this new rule when it comes out. And again, the contractual term between an employer and a worker requires the worker pay the employer a third party for training costs. This is another post-employment restrictive covenant that says, hey, look, if you're going to quit my company, I'm going to make you pay for your training. And that training requirement is going to stop you from going to work for a competitor. And these are the ways the FTC is looking really carefully at what people are doing in these private employment relationships. We have some more definitions of employer and employment, and also an idea of substantial owner or substantial member or substantial partner. What this piece means within this proposed rule is it's not going to generally apply to the sale of a business. You have a business, you sell that to a new company, that new entity is going to lock you in. They're going to say, look, I'm not going to buy a business just so you can spin around and do it again. When I buy you, I'm going to stop you from doing this kind of work. Now, they also define worker. Look, this is important. This is not just for W-2 people. This is anything from independent contractors, externs, interns, volunteers, apprentices, sole proprietors, all the things. So whatever the hiring entity calls you, that is likely going to be not that important for the purposes of this proposed rule. They are expansive in determining who is someone who is a worker that'll be covered by this big, big move. Back to the next part, the unfair methods and competition. So unfair method competition, this is what the FTC is all about. I'll just scroll down here real quickly. We'll come back up to that. But right here, you see the authority. This authority is what the FTC is saying. They're saying, look, that's what gives us the power to do this. We have the right to stop people from doing these types of relationships that are so negative for so many people. So unfair competition, I'm going to read this verbatim. It's important to understand it. Unfair methods of competition. It is an unfair method of competition for an employer to enter into or attempt to enter into a non-compete clause with a worker, maintain with a worker a non-compete clause, or represent to a worker that the worker is subject to a non-compete clause where the employer has no good faith basis to believe that the worker is subject to an enforceable non-compete. Ooh, that's interesting. What this is telling us is that they are not going to be able to tell you that you are subject to a non-compete. Once they're banned by this rule, you are breaking the law if you say your people are bound by a non-compete. Now, it doesn't just stop with the going forward with non-competes, like join my company, here's a non-compete. There's a part of rescission. This is amazing. This is the thing that gets me really, really excited. Here's what it is. An employer that entered into a non-compete clause with a worker prior to the date this law goes into effect, this rule goes into effect, must rescind the non-compete clause no later than the compliance date. What that means is that if you have signed a non-compete before this rule goes into effect, it is done. It is gone. It is rescinded. This is why so many business entities are in a panic, an absolute panic. So many of these companies that have put in place non-competition agreements, they are done for a couple of reasons. One reason is it can improve retention. You're so scared of leaving because I will sue you into oblivion, you don't go anywhere. Number two, it starves your competitors of talent. If I can't take your customer as a competitor, I can certainly stop you from taking talent. And every effective company is a combination of three things: technology, processes, and people. If I can starve you for talent, that is exactly what I'm going to do. So this rescission means, oh my goodness, every single person that has signed the non-compete in my company is no longer bound by it. This is what we've all been talking about so much in the proposed rule, but it gets way more fun. This is the part that made me want to make this video today because it is absolutely fascinating. Okay, so we banned the non-compete. So we've rescinded the non-compete. How do your people know? How do they know it's gone? What do they have to do? That's when we get into the notice requirement. Notice is something really, really special, and it does something very, very cool in this case. So, notice requirements under this paragraph 2, and I'm going to read it verbatim, and then I'm going to talk to you about what pieces you should be focusing on. Quote, an employer that rescinds a non-compete clause pursuant to paragraph B1 of this section must provide notice to the worker that the worker's non-compete clause is no longer valid in effect and may not be enforced against the worker. The employer must provide the notice to the worker in an individualized communication. The employer must provide the notice on paper or in a digital format, such as, for example, an email, a text message. The employer must provide the notice to the worker within 45 days of rescinding the clause. Wow. Wow. That is interesting. Because here's the deal. The employer must provide notice to the worker that the worker's non-compete clause is no longer in effect and may not be enforced against the worker. They have to tell you through an individualized communication. Imagine a company with 1,000 employees knowing half of them are bound by the non-compete, having to send each and every one of those people notice and saying, hey, Remember that thing that you signed? It's no longer valid. More importantly, and what makes me excited, is that many people sign non-competition agreements never knowing that they did. Look, 30 million Americans have signed a non-competition agreement right now. How many of them do you think know they signed that document? You're going to have people that don't even understand that they signed a non-competition agreement, having to receive communication from the HR department saying, hey, you may not be aware, but we have you on record as signing a non-competition agreement. Just so you know, it's gone. This is going to cause so much strife within corporate America. You are watching competitors in the space that use these things having a massive tearing away of the leadership who prefers the non-competition agreements and all of the workers who absolutely despise them. More importantly, what are you going to do as a business? You have to plan. You now know this is happening. You know the rule is coming. You can say to yourself, well, maybe they'll sue and stop it. But as a business, you must prepare for each contingency. You simply can't put your hand or your head in the sand and say, I'm just not going to do anything. No, 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 no. No. You are going to go to your HR team. You're going to go to your lawyers and you're going to say, what are we going to do? What are we going to do? There's a real question. Does the FTC have authority to do this? But let me give you a little spoiler. The states, California, Texas, Oklahoma, Illinois, New York, any of these states individually can ban non-competes outright. And some of them do. Some of them do. It's a question whether the feds can do it. But even if it's a question whether the feds can do it or not, as a business, you have to manage risk. If you choose not to do anything, you will be doing damage to your company. You will be doing a disservice to your shareholders. And there's a real question. There's a real question is if you fail to act, will you breach your fiduciary duties as a board member or a C-level executive? I think you might. I think you might. So here we go. It gets even better, folks. It gets even better. So this is about notifying the current workers of the non-competition agreement. The employer must also provide notice to a worker who formerly worked for the employer, provided the employer has the worker's contact information readily available. Oh, wow. Wow. No, we're not just talking about our current employees and giving them notice. No, 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 no. It's so much more than that. You have to tell your former employees if you have their data, their contact information. Imagine this. You have companies with churn rates of employees of 90%. Hire 10, lose 9. Attrition, they go away. But they're still bound by that little non-compete. What's going to happen when you now have to proactively reach out to your former people and say, by the way, I remember you didn't leave in great spirits with our company, but let me just remind you that now you can compete with me directly. Notice. Oh, notice. It's not just for your current people. It's for all of your people. It is for your former people. You are not done when you've complied with your existing workforce. This is fascinating. So we're going to go through this. There's a little bit more about like what you have to say, what you're going to have to communicate, how much time you have. But this is the meat and the potatoes of this. Now, look, there's a safe harbor. An employer complies with the rescission requirement if they provide the notice worker pursuant to section B2. So they're saying, look, do your best. Do your best. Send a text. Send a blanket email. Send it to everybody. It's individualized. You can't just do a blanket saying, hey, you XYZ person may have signed this. No, you did this. You, this person have signed this. There's some exceptions, right? And this is the part I think we are going to see some changes at the FTC. This exception group is probably not good enough. I think there's going to be some changes. But just an example, it does not apply to a non-compete clause that is entered into by a person who is selling a business entity or otherwise disposing of all of the person's ownership interest in a business entity. We use this legal phrase, substantial owner, substantial member, substantial partner. Again, that's defined previously in the definition section, saying 25%, something like that. I believe that is going to be a good rule. I think they're going to have to modify that for senior level people. If you're C-level folks, chief executive officer, chief operating officer, chief technology officer, I think those non-competes are probably going to be modified. I think you're going to see comments happening describing that piece of it. But relation to state law, right? Look, this supersedes any state law statute. Supremacy. So in our democracy, we have the separation of powers, but we know the feds are supreme. Supremacy clause. If there's a conflict between the state law, like Ohio, thinking of somebody in Ohio who uses a lot of non-competition agreements, and the feds smash it. They smash it into oblivion. The feds win. So you can have a state with maybe more protections, getting rid of more non-competes. But if the feds ban them in this version, every state that allows them, it's over. It's done. Supremacy. That is the whole idea of they will supersede under this piece. Compliance date. This is the timing aspect, folks. This is where we're going to talk about civil procedure, and then we'll answer some of your questions. Here's what's going to happen next, right? So you have the proposed rule. In a couple of days, Monday, Tuesday, Wednesday, one of these days, that will open up for public comment. And I will make a post, maybe a video, showing you how to make a comment. The comment period is 60 days. For 60 days, anybody, you, me, every corporation, every lobbying organization, anybody can make comments into the Federal Register. Once those comments are done, the agency, the FTC, takes them and says, okay, let's make a final rule. That final rule will take some time. It doesn't happen automatically. It's not magic. It has to have some things happen. Once the final rule is published, this proposed rule, 180 days after publication, this is going to move quickly. It will not move slowly. Many people think, maybe it's just a lot of much ado about nothing. No, I don't think so. So once the proposed rule is put into the Federal Register, we can comment. When the comment period is open, a final rule is made. When the final rule is made, the world changes. Now, things will happen. Just like I mentioned before, the biggest thing we're going to see on this issue is right here. 15 USC 45 and 46G. These are the authority that the FTC is claiming gives them the right to make this proposed rule. And I think they're right. I think they do, but the U.S. Chamber of Commerce and others do not. They do not think that the FTC has the authority to do this. And they will challenge the rule and say, you lack authority. This is a major question of the law. We don't want the government in our private contractual relationships. This will be appealed. District Court, Federal Court, SCOTUS, the Supreme Court of the United States of America. It will likely go to SCOTUS. I have very little doubt this will make it up to SCOTUS. Now, the feds at the FTC may question the authority of what they can do. That will happen. But remember, there is bicameral legislation in the Congress right now, the Workforce Mobility Act. We talked about it earlier. That can still pass. And if that passes and gets signed into law, all this is moot, because that will absolutely have the authority that is necessary to ban non-competition agreements. Even if the Workforce Mobility Act isn't passed, and this rule is knocked down, your state can still ban non-competition agreements. But what I am just so excited about, I'm so excited about, is this: that written notification, individualized communication to every worker and former worker who you have contact information for, letting them know that, hey, that non-compete that you really didn't want to sign to begin with, it's invalid. Now, we have some comments, so let's bounce over to the comment section. Here we go. We're going to start off with my good buddy, Scott Watanabe. Here we go. Oh, thank you. You know what? I love breaking down the law. It's like an unboxing video. We don't know what we're going to find when we get that proposed rule. We just want to dig into it a little bit. It's a good time. Let's see. We got Brandon Weissman. I love Brandon Weissman. He's a good dude. FTC's purported authority here seems specious. My gut is telling me it will be enjoined and tied up in the court for years if it progresses to the final rule. I don't disagree with Brandon. I do think the FTC has authority because at the end of the day, this is a deeply unfair competition practice to deny your competitors of good talent. And the data is very clear in terms of how many people are affected by this. But if people are worried about that level of authority, we have other paths. We have the Workforce Mobility Act. We have your individual states can legislate against this. I will say on the final rule side, this will pass. There will be a final rule. There's no doubt in my mind we will have a final rule. It will be sued and it will probably be enjoined. But man, I'm hoping it's not. I'm hoping it's not. Are nationwide non-competes valid? Seems pretty far scaling. Yeah. So non-competition agreements, remember the things we care about is how long, 1 year, 2 years, whatever, how wide, is it your city, your state, your country, the world? And then what is the thing you can't do? Blanket non-competition agreements that go for an entire state or entire country can be enforceable. It depends on the state it's based out of, but it can certainly be enforceable. That being said, if you live in a state that bans them, like California, go pound sand. You're never going to get that enforced, but they certainly can be all encompassing. That's what they do. I'll use an example of Jimmy John's, right? So Jimmy John's, freaky fast sandwiches and really shitty non-competition agreements. They had every single worker sign one that had 2 years for non-competition, and you were banned from working in any cold sandwich shop within, I think it was 2 or 3 miles from any Jimmy John's facility. That was eventually found to be unenforceable because it was with sandwich shop workers. But it's very clear in our sales business that you do have them. Barry's talking about TQL. Yeah, TQL is going to have some problems. If this thing passes, they are going to struggle, and it's good that they do. You can't be the biggest around and coerce your employees to continue working for you. You just can't. This will change as time goes on, I think. Let's see. I have a question about the rescinding. Will it also impact separation agreements that were built upon the original non-compete? Absolutely. 100%. Like if there's a non-competition agreement, part of a severance agreement, that non-competition clause is done, rescinded, unless Eric, you are selling your business. You're selling your business. You have a non-competition agreement. You're not going to get to do that business again for a period of time. But absolutely, this would knock those things out. Barry, again, I'm guessing the opening, the comments will be overloaded this first week, making it hard to make a comment. I don't think so. This is a controversial rule, but not really that big of a deal compared to other things we've seen. When the comment period opens, I will post about this. I will put links to it. If you can start drafting it now, tell your story. Here's what's going to happen with our democracy and our government. If the government understands that our supply chain is made less efficient because of non-competition agreements, if we're not having a good outcome for consumers because of non-competition agreements, that is going to be really, really important. Many people think of non-competes outside of the context of supply chain. They think about it in all sorts of other business cases, but in supply chain specifically, that story of how non-competes ruin people's lives and make it difficult for consumers to get products because the best of the best don't get to work in the field. That's important. That's really important. Dan's got a point here. What happens if an individual and a company are in legal proceedings over a non-compete when it goes into effect? Oh, that's beautiful. So let's say I'm representing somebody who is being sued for a non-competition agreement, and we're in court, and this rule comes out. I make a motion to dismiss tomorrow. I say, here's the rule. This is it. We're done. This would stop the litigation. So for all of these companies all across the country, like, man, wouldn't it be great if we could stop having all this litigation with our former employees? Yeah, this is one of the ways you do it. You ban non-competes and you make it so that you can't enforce them in any court of law in the country. So if this happens, all those existing cases, pause, dismissed, done, we're moving on. It's going to be really, really cool. Okay, Eric, yeah, I'm happy, man. This is what we do. This is what we do, man. I want you to understand your legal system. It's hard. It's complicated. It's messy. However, this is your life. This is your family's life. This is when your son or your daughter gets their first job. They say, Mom, Dad, I got this offer, and it's got this 4-page long non-competition agreement. What should I do? We are trying to protect Americans. That is what the FTC wants to do. So here's another question here. If Florida is a state of the non-compete signing for 1 year enforceable, you mentioned California, but there's others where non-competes are not enforceable. Don't take legal advice from a podcast or a television show, or whatever the heck this thing is that we're doing. You have to check with your local lawyers. You can do a quick Google search, non-competitions in Florida, but always find an attorney who can help you understand what your non-competition agreement looks like. Florida, as far as I know, and you'd have to get an attorney to validate this, does permit non-competition agreements. And I will say this, and this is not to be political, but it kind of ends up being that way. The more liberal the state, the more rigorous they scrutinize non-competes. The more conservative the state, the more they allow non-competition agreements. And the reasoning behind this, generally speaking, is that a conservative state will say, we don't want to get in the middle of private people making contracts. Let them do what they want to do. On the other side, what the liberals will typically say is, these are not fair negotiations. These are not arm's length transactions between sophisticated buyers of something. These are between a massive company, generally, who has legal resources to fuck you if they want to, and you, the individual, who doesn't understand, doesn't have time, doesn't have the money to get a lawyer. So I tend to agree on the liberal side, at least in terms of non-competition and enforceability, but that's where you're going to find these differences, generally speaking. And that's all the questions right now, folks. We're at 32 minutes. I really hope you enjoyed this. I really hope that this helped you understand what this rule is all about and helps you understand what is at stake. And let me be clear. What is at stake is the mobility of Americans to do the profession they've trained to do. Oftentimes, when they get a non-competition agreement, it is done after they have already agreed to do the new job. And once they do the new job and they're given this non-competition agreement, it is sign or get the heck out, you're fired. That is exactly what happens. And we have been wrestling with this since the end of the Civil War. I recently did a continuing legal education seminar with a company called Lawline about non-competition agreements. These things happened after the Civil War when slavery was abolished. And the people said, well, how can we lock people into still working for us and stopping them from going off and doing their own thing? That's what these things are. They affect everybody. It is not just executives. It is not just business owners. It is entry-level salespeople and janitors and sandwich makers and every other person you can imagine. 1 in 5 Americans are bound by a non-competition agreement. And at the end of the day, if this rule passes in the form we see it today, they are all illegal. They are gone. The existing ones are rescinded. They are gone. And employers and hiring entities will have to communicate with everybody, internally and externally, that those rules, those non-competition agreements are no longer in effect. The friction and the breaking apart of the relationship between management and workers is very interesting. If you are a company who has decided as a business rationale to have non-competition agreements as part of your onboarding process, you will be the aberration. You will be the weird one, the wrong one, the one that no one wants to work for. And if the feds don't stop you in 2 months or whenever the final rule comes out, the state might. And if the state doesn't stop you, I urge you, everyone watching, listening, thinking, and hearing this, look at the bicameral legislation that has already been proposed. This is something that we really want to focus on. The last comment here from my good buddy Dan: will individuals defending themselves against non-competition agreements be able to recover legal fees from the company if this goes through? That is a great question. And the answer to that, as any lawyer will tell you, is it depends. I'm going to keep the question up because I think it's really interesting. There is nothing, as far as I have seen so far, of fee shifting provisions in this proposed rule. However, every single contract that is entered into between a hiring entity and the worker generally has some sort of fee shifting provision. Now, I have seen fee shifting provisions that say only the company can get their fees recovered if they win. But there are many, and in every contract I draft, it goes always to the prevailing party. If the contract says the prevailing party gets paid their legal fees, and this thing passes, and you're in litigation, and you get it dismissed, guess what? You won. You prevailed. And every lawyer who's representing you will say, you have contractual fee shifting for the prevailing party? That's awesome, because now your hiring entity is not just going to have to walk away from the non-competition agreement. They may actually have to pay the $500 an hour legal bill from your attorney who's been defending you. I think that would likely be the case. Again, check with your lawyers when you're in litigation, but every single person who is actively in litigation on non-competition agreements should be watching this thing with starry eyes, excitement. We have been waiting for something to happen. We have been waiting for someone to do the right thing. Congress nearly did it. It got stopped. Some states have done it. They keep pushing. But there are pathways on the federal side to stop this. So we're getting close to 40 minutes. I am so happy you took your Saturday morning, right, to say, let's learn a little bit more about non-competition agreements. When this is all said and done, you'll find this full video on my YouTube channel. I will put it into the podcast, Armchair Attorney, Spotify, and Apple Podcasts. Thank you for joining me. If you have any questions, let me know. Barry, you're right. If this happens, I think TQL goes bye-bye. I think they have enough litigation. Ooh, it'll be fun. It'll be fun. All right, everybody, have a great day. Have a great weekend. It's been great talking to you. I hope this was educational, entertaining, and at the end of the day, things are going to be better. Always bet on good winning. Thank you so much, and have a great day. Bye. And I hit the button and it ends. Woo!